Hello, good morning, good afternoon, good evening, and welcome to Oxford Arbitration Day keynote speaker interview with Honorable Charles Brouwer. Good afternoon, Judge Brouwer.
Good afternoon. I mean, it's good morning here, but that's
good. Okay.
No,
right.
It's technically afternoon. That's true.
There we go. There we go. Well, first and foremost, thank you very much for all the attendees for their loyal signing and patience to stay tuned on a Friday, perhaps Friday afternoon or Friday evening, for the last portion of this program. I can assure you that's going to be worth waiting. Thank you very much for André Monteiro, Dall'Agnol, Felipe Sperandio, João Moreira, and Lauro Parente for organizing such a wonderful program. I am so pleased, so honored and privileged to be the person to introduce and to interview Judge Charles Brouwer. Judge Brouwer has a long profile, but what I can say is, as a matter of introduction, he has in his 55-year career, he's been in the law, in public service, both national and international. For nearly 40 years, he has focused on public international law and international dispute resolution. And with that very tiny introduction, because we have plenty of issues to cover, why don't we get started, Judge Brouwer?
And, I'm ready.
Okay. And why don't you, as for the sake of introduction, why don't you just tell us a little bit how, when, and where did you start your legal career?
I started just when I graduated from Harvard Law School with the law firm White and Case, now known as White and Case LLP, which has become very much a global law firm. I was in New York for 8 years. That was
when was that?
1961.
Okay.
Right. And I was there for almost 8 years. I became a partner there basically as a general commercial litigator, doing all kinds of interesting things like defending exploding beer bottle complaints for Budweiser, things you wouldn't think that's where I really became, how should I say, a real lawyer. But I resigned from the firm 4 months to the day after becoming a partner to go to the State Department in the Office of the Legal Advisor for 4 years in the Nixon administration, and then White and Case opened an office in Washington, where I was off and on for many years, excluding the years that I've been in The Hague. Total of 21 and a half years in The Hague as a judge of the United States Claims Tribunal, and now sitting in 3 cases as a judge ad hoc of the International Court of Justice. So,
okay. During your period, your tenure at White and Case, did you have any contact with international arbitration by then?
Not really. You realize in 1961 there wasn't much in the way of international arbitration. Anyone interested in doing international work had to be doing corporate transactional work, and I found that anathema. I was in litigation, and I like to how should I say? I shouldn't say fight, but match wits in real time with other counsel and to some extent with judges.
Okay. And let me ask you some sort of a personal question here in terms of you have this 50-year career, stellar career, I would say. Would you have any specific hobby or anything that you like to do outside the legal environment?
Every time I'm confronted with a form for biography, and it asks you at the end any hobbies, and the reality is, all my professional life, I've been living my hobby. And that's not to say that I'm necessarily a workaholic, although I suppose I might qualify. I just love what I do, and I keep on doing it. I say, when I'm asked, gee whiz, you haven't retired? And I said, it's not in my vocabulary. I will be retired by forces beyond my control. So, but if I were to fill it in, apart from what I've just said, I think I would say I love to host very nice dinners with up to 12 or so people who actually have something to bring to the table culturally, intellectually, with the very best of food and the most excellent wines, and all infused with a really educational, interesting, and pleasant conversation about all sorts of subjects.
Interesting, and I love hearing that this expression. I am living my hobby. This is fascinating. This is already a piece of advice to current and especially to the young generation. Do what you love, and love what you do. And so this is something that I can get from your comment.
If you have the opportunity, that's the only way to go. I say I've never had a job. In the sense of, doing something for pay that maybe is not your ideal. I've been blessed that way. And so that's
certainly you are. Yeah, certainly. Why don't we move now to your service, your performance, in your role in the Iran and in the United States Claims Tribunal. As I understand, you served as judge in this tribunal for many years, and perhaps you are still there. But so, can you just share some highlights of such experience, please?
Well, it's been a very interesting experience. It seems that Iran, although I've never been there in my life, has infused many years of my professional life, both as advocate, mostly as a judge of the Iran-United States Claims Tribunal, now as a judge ad hoc of the International Court of Justice. It's very, very interesting. Obviously, it's quite an achievement that these two countries, which have not had diplomatic relations since about April of 1980, when President Carter launched a failed raid of the Delta Force at Desert One in an attempt to try and extract the 52 hostages. And yet, we all get together in The Hague. It's been going on since 1981, actually. And we've been through different phases. At the beginning, they really sent, how should I say, revolutionary devotees. It was less pleasant. And in fact, on the 4th of September 1984, two of the then Iranian judges physically attacked one of the third country judges, an elderly Swedish judge who happened to be chairman of the chamber in which I was sitting. In those days, we were mostly working in chambers of three, one American, one Iranian, and chaired by a third country. Eventually, this tells you something about how sort of the Iranian mind works. Those two are challenged by the United States. And while a challenge was pending, of course, Iran did not do what it could have done, which is say, we accept the challenge and we'll send some new people. We just got to, while a challenge was still pending, and I think it would have been granted for obvious reasons, we just got the president of the tribunal received a letter from the agent for Iran saying, starting on such and such a date, 2 new judges will arrive from Iran, which the majority of the tribunal then decided was actually an acceptance of the challenge. And of course, those 2 people left and were replaced by by 2 others, with one exception, which is very unusual but understandable by because of the circumstances. It has never happened that any of the 3 Iranian judges, were 3 Americans, 3 Iranians, and 3 third country nationals. No Iranian has ever voted other than for the position of the Islamic Republic of Iran. Of course, American judges have voted differently at times, even to find there's no jurisdiction, and to sometimes find that it just wasn't a good case for the American claimant on the merits. You might say those are rare. They're not numerous, but essentially the tribunal was established to pay off American claimants on such claims as were justified. Had very few Iranian claimants, although they could have come near. It's an interesting experience, and I was confronted once early on there, when I was there back in the 80s. I've been there at 2 different times, actually physically living in The Hague. My Iranian colleague, whose family still lives in the Netherlands, although he does some work, of course, in Iran, said, "You know the difference between you Americans and us Iranians?" And I said, "Well, I think you're going to tell me." And he said, "Yes." He said, "The house that we live in has a ground floor in the front and then a floor below that, which opens out into a garden with sliding doors. And we were up on the ground floor in the kitchen one evening, and I heard sounds as though someone maybe had entered below. And so I went down there, and yes, someone had come in. As soon as he saw me, he ran out the back. I ran out the back. We had a fence or a wall around our garden. He leapt over that. I leapt over that, and I chased him as hard as I could down the street. Now, he was able to outrun me, but if I had ever caught him, I would have beaten the living daylights out of him. Now, he said, that happens in America. What does an American do? American goes down, sees, oh, the guy's out. He's gone. He's over the fence. Yeah, okay. Maybe you call the police. But that's the difference between us, he said. Okay. And there's a lot of truth in that.
Interesting. And I'm going to as we move along, I'm going to touch on some cultural differences,
yes,
and especially in the field of international arbitration. But just to close this topic, if you can and if you may, what are the remaining issues before the tribunal? If you can share with us.
Right. Well, since I resumed residence there at the beginning of 2001, we were already then just dealing with cases between the 2 states, between Iran and the United States. And those cases, some of them are contractual cases. usually dealing with foreign military sales program that the United States had. All of they take a long time because they're all done with all 9 judges. We have no cases in chambers anymore. And I tell you, the other Iranian quality, which has been confirmed to me by Iranian friends one makes along the way in the tribunal, is you just don't give up arguing in deliberations unless and until either one of 2 things happens. The president of the tribunal says that's enough, which is a rarity, or they become convinced that there simply is no more room. They're just, that's it. That doesn't happen a lot at the tribunal, so the deliberations can be extremely long. And I remember attending a White and Case, my former firm, event back in the 80s in New York, and I was, why do you want to be in The Hague and doing what you're doing with these Iranian revolutionaries instead of enjoying the glories of litigation in the city of New York and in the United States? And I said, I have to tell you, everything I ever learned as a New York City street fighting brass knuckles litigator, which is somewhat typical of a lot that goes on in New York City, is totally applicable to deliberating at the Iran-United States Claims Tribunal, with the Iranians basically on the other side and everybody competing for the favor or the vote of the third country members.
Interesting. Very fascinating experience. It's a patience experience as well. Let's move now to arbitration. When and how did you start you make your first steps in the world of international arbitration?
Right. I would say it was in 1979 or 1980. I mean, I was already 40 years old before the first arbitration came along, because it's a field that's developed only after I had arrived on the threshold of middle age.
Was it domestic or international arbitration, if I may ask?
I'm sorry, it was...
Was it a domestic, purely domestic case,
actually,
or international case?
No, my very first case was an ICSID. It was one of the very first ICSID cases.
Okay.
We had been representing Indonesia for some times, and a case which sort of ICSID devotees will recognize, the AMCO Asia case versus Indonesia. And I saw that was happening, and so I wasn't contacted by Indonesia, but I saw there was this case, so I prepared a memorandum about the case and what they should do, and so on and so forth. In any event, that was the first one, and the next one came soon after that. Was chosen to represent some good old boys from Oklahoma who were a big driller for oil and gas on land, and they had a problem in Algeria. And so as soon as I had 2 cases, I decided, okay, comparatively speaking, I'm an expert, and went out on the speaking circuit, and and the rest is, and then pretty soon I was appointed by the Reagan administration to the Iran-United States Claims Tribunal. And when I came back from that after between 4 and 5 years in 1988, that had given me a profile as well as an acquaintance with various American international arbitration lawyers who had cases before me at the Iran-United States Claims Tribunal. So that really helped me develop that practice for me and for the firm.
I certainly believe so. What a dynamic professional career. now, in terms of international arbitration, or even domestic or arbitration as a whole, in your opinion, what are the most important characteristics of an arbitrator, an international arbitrator? It can be also investment state, international commercial, or domestic. What is the most important characteristic of an arbitrator?
Well, in a word, I guess I would say to be an internationalist. Of course, an excellent lawyer, but someone who possibly has command of a language or two other than one's native language, one who knows the world more than many people do, appreciates the different cultures and the influences that they may have on the views of colleagues. It's being an international arbitrator has actually been a wonderful way of meeting some of the most impressive and interesting and sometimes entertaining also people one can imagine, but they need to have a clear mind, total independence, impartiality, and I never thought I would become a judge of any kind, and I've not been a domestic judge, obviously. But when I arrived at the Iran-United States Claims Tribunal after a career of representing clients, I thought, gee whiz, this is really great. The salary comes in every month regularly, and it was very respectable at the Iran-United States Claims Tribunal, and my only duty is to do what I decide must be the right thing in the case without any concerns about partners in the firm, clients, so on and so forth. It's really a liberating
interesting. Of course, impartiality, independence, these are very cornerstone of arbitrators' service. But you've mentioned also some understanding or having knowledge with maybe language.
Yes.
So from what you said, I understand that it is important, or it is a plus, to speak other languages so that you can understand better what, or even not only language-wise, but also cultural-wise, what counsel is trying to say. Do you think that being a polyglot, do you think it really helps, or sometimes it does not help? Because once you need some translator or interpreter before the tribunal, and you know that the translator is not translating the way you understand because you speak the second language, when the witness is speaking his or her own language, and you understand, but the interpreter somehow didn't catch or didn't get the point, and there is some sort of a mistranslation. Do you leave this situation that, according to you, to the opposing counsel in order to address this, or you intervene?
Well, that's a very interesting question. I'm trying to remember situations where I've been first off the mark. I think in those situations, actually, a member of the counsel team always has the assignment of monitoring the simultaneous interpretation, and they're very fast, very quick at saying something is wrong. So I haven't been in a position of being the first to say something on that, although I may well have noticed something. But we're always they're faster on the draw, as they used to say in the Old West in my country, than the arbitrators.
Okay. You may have covered already this one, but just to make sure that we are on the same page, if you will, from the arbitrator's perspective, what are the main differences and caveats in handling international commercial vis-a-vis international or investment state arbitration? By the way, is there any difference from the perspective of the arbitrator?
Well, I was privileged to give what's known as the Alexander Lecture some years ago for the Chartered Institute of Arbitrators, and in which I coined the term, which I've rarely heard since, but some people have picked it up, investomercial arbitration. I think that the classic distinction between commercial arbitration and investor-state arbitration is somewhat a false separation. The real difference is whether you have a state party, normally respondent, obviously, although it happens the other way around sometimes. As soon as you have a state involved or a state entity, particularly a wholly owned state oil company of an oil producing country, you're in a different, you're in a potential circus that virtually never applies when you have two private parties, no state ownership, with a contractual problem. When states and governments and politicians and big demands by claimants are involved, you will have a wholly different experience than if you have a strictly private arbitration. And of course, the law is different. Treaties are involved in some cases. Contracts and treaties are involved in some cases. And sometimes with states, only a contract is involved. Still, that happens. So while the rules under which you're playing and the governing law will very likely be different, it's a whole different operation. So it's some cases are political, no matter what the basis is, and you will have a lot of experiences that you are not likely to have in a strictly two private parties working off a contract case.
Interesting. Let me move now to a topic of confidentiality. Investment state cases, they are public by nature, and as a result, they create a sort of case law for the users, for everyone who are interested in investment in state cases. On the other hand, international commercial arbitration are not so. Although there is a trend of disclosing more data, more information for the arbitral community as a whole, my question to you is, do you think the confidentiality, let me put it this way, what do you think is going to be the future of confidentiality in international commercial arbitration?
Oh, the situation with, I will say, arbitrations between two strictly private parties is it's the rare case in which either party wants a lot of publicity about it. And often there are issues of commercial secrets or trade secrets that don't want to be disclosed, that people don't want disclosed. So I don't see that that's going to be become a trend. And of course, there's a situation where let's say maritime arbitration, where you have certain people doing all of the cases. They'll know all they need to know anyhow. Just as arbitrators who are, and there are such who are frequently appointed by insurers or reinsurers in catastrophic liability cases. You get to know all the cases. If you sit in enough of them, you know all you need to know. The situation is much different with respect to cases involving governments. Actually, the cases in which governments have fought against disclosure, I have judged to be cases in which the government doesn't want the people of the country to know what's going on. That does happen from time to time. And then there are others, such as under the NAFTA regime, which is now changing, but probably not in this regard, where Canada and the United States and Mexico wanted everything. They'd post everything on their foreign office or relevant ministry websites, and obviously transparency is just increasing like mad in the field of cases involving governments.
Correct. Yes, correct. Okay. Let me touch on a topic. Oh, by the way, for the record, I have prepared some questions here for Judge Brouwer without any assistance from Judge Brouwer. So this is something that I prepare myself, and I am taking this advantage of raising those questions as we move along. Now, in terms of appeals, we've mentioned users, right? So users mean states or private parties, etc. But we can see today that some institutions, they start amending their arbitration rules to include an opt-in appeal mechanism. Do you think this is a trend? Do you think this is something that, well, first of all, do you think this is showing something for the arbitration as a method of solving conflict as a whole? Or do you think this is just an option that parties may have according to their, once they draft the agreement, they may say, well, let's put this on appeal in the arbitration system. But what is your opinion regarding this scenario? Is it a trend, or this is just is not a trend?
Well, since it never existed until not too many years ago, I guess you could, and it now does. It's you might say it's a trend in a sense, but it doesn't seem to me a very excuse me, a very strong trend, other than the fact that the European Union concept of having a 15-member, all state-appointed international investment court, which I have spoken and written very much against, and as an observer at Working Group 3 of UNCITRAL, certainly have spoken against that, envisages an appeal mechanism. It'll appeal to some, but not to others. If, for example, you're a major multinational corporation, while you do care whether you win or lose, the reality is you'll have a certain number of arbitrations, and some of them you'll wish to have a continuing relationship with the other party, particularly if it's not one of these cases where a government and an investor have a complete falling out and there isn't any potential future relationship. But you basically, I think, the major multinational users of arbitration, they want to get a result and move on. Okay. They don't want to be dragged out forever as though they were in court. There may be others who, for whatever reason, maybe states, they don't care. They want to win, and sometimes they don't care what it costs. So it varies. I don't know where it's going.
Yeah, interesting. And I raised this because in one of my cases, I was sitting as an arbitrator, and the clause called for an appeal. And during the preparatory conference, preliminary conference, or case management conference, whatever you call. So I try to discuss with parties if they really wanted to keep that provision, and they said yes. I was expecting a no answer, but the answer was yes. So it was interesting. Let me step back to arbitrator's appointment.
Yes.
And this is something very interesting. In 2013, you co-authored an article at the Arbitration International called "The Death and Two-Headed Nightingale: Why the Paulson-Vandenberg Presumption that Party-Appointed Arbitrators Are Untrustworthy and Wrong-Headed." So my question to you is party-appointed arbitrator at stake, or rather it represents a well-established right of the parties in an essential phase of the arbitration process?
Well, I think that the arbitration, which is a consensual process, is definitely furthered by the fact that each party, each side of a case, is involved not just in the selection of one arbitrator, but in the usual three-member tribunal. They have a role directly or indirectly through an appointing authority of having, including a role in the appointment of the president of the tribunal. So it's very important for them to have the buy-in. They're part of the construction of the tribunal, which will judge them, and nobody likes to lose, but it's a different situation if you've had a role in composing the tribunal. I think that's that's extremely important. Those who deal with the International Court of Justice will be aware of the fact that where there's a contentious case between two states, and if one of them, with respect to one of them or with respect to both of them, none of the 15 elected members of the International Court of Justice as the nationality of that country or either of those countries have a right to appoint, for the purposes of that case, someone as judge ad hoc who has all of the powers and rights and so forth of any judge of the tribunal for the purposes of that case. This was invented by Elihu Root a long ago, early 20th century Secretary of State and a great New York lawyer, and it's been carried forward since the establishment of the Permanent Court of International Justice following the Treaty of Versailles until today. Having buy-in, a role in it, makes a difference. And I think that if the European Union thought of having a 15-member international investment court composed only of people who are appointed by states, will drive people who have the opportunity to stay away from it, to try and stay away from it, either through contractual relations instead of relying on a treaty or whatever else they can figure out. It's essential to the success of arbitration.
Okay. Wouldn't you be concerned with now? There are so many players in international arbitrators, and by players I mean parties, arbitrators, counsel, experienced and unexperienced counsel, arbitrators, and parties. Wouldn't you be concerned that the possible interview between counsel and potential arbitrator would go a little bit too far based on this proliferation of parties, arbitrators, and counsel, or it's not a matter of concern?
Well, I think one does need to be careful. I'll be frank to say I have always submitted to interviews by a party considering appointing me as a party-appointed arbitrator. I've not been interviewed by both parties for the position of president or chairman of the tribunal. That rarely happens in practice. But unlike some of my confrères, I submit to arbitrations because I think if the party wants to do that, it's because the management, not just the council, want to be comfortable with the choice. If it isn't someone who already knows me, and usually the parties don't know me before. Often the council are. They have to be satisfied because if things go south in the case, the general counsel is going to want to say, look, first of all, I collaborated with our outside counsel, and this was a real star. It's someone that nobody can attack, basically, and the president needs to, CEO needs to answer to the board. So if people want to get comfortable, and I've had them travel a long way sometimes to interview me in the Hague, and frankly, I arrange they can have lunch with me in the Restaurant des Juges, which is reserved otherwise for diplomats and judges and so forth, or people involved in the Peace Palace. I think they should do that. Now, of course, I've never has any counsel ever looked like he or she was going to cross the line of what's appropriate. We talk about family, our country's culture.
Right.
They just need to know if want to be sure. They'll know ahead of time whether they have a conflict, obviously.
Right.
So I think that's the right thing to do.
Right. Yeah. Yes, I agree. Yes, the arbitrator's behavior and position is very important to set up these limits, these boundaries.
Yeah. Oh, yeah. Absolutely.
Yeah. So let's move to counsel then. How would you describe a good counsel in international arbitration? And any particular piece of advice to the young and even the current generation regarding a good counsel?
Right. Well, know your case. Basically, be honest with the tribunal and be polite and respectful, and don't get into intellectual fistfights with opposing counsel. That gets nobody anywhere. It's just a distraction. And, sometimes you have a horrible counsel before you, but it turns out their client has the right side of the case. And you have to, I've been in cases where you say, well, in a sense, it's too bad that the party represented by this person who has just, been the source of torture has the right side of the case. But that's how you have to decide. But there's no need for the unpleasantness along the way. Be aware and don't hide the weaknesses of your case, and be aware but don't overstate the strength of your case. The people who are most successful, and I know most respected by other arbitrators, are those who are just very straightforward, and as I say, polite, respectful, well-behaved, but know how to present a case and present it right. That's the only way to go.
Yes, and you've mentioned know your case.
Oh yeah.
I would add know your audience as
yes.
well. right? So how to present a case before an arbitral tribunal composed of civil law lawyers, or a tribunal composed of only common law lawyers.
Yeah.
So on that regard, so perhaps we could go to a topic of soft laws, that they are there in order to bridge these differences and different cultural idiosyncrasies, etc. Do you really think those soft laws, they help to bridge these different cultures and different idiosyncrasies? Or do you think a good arbitrator, an experienced arbitrator, a good counsel, an experienced counsel would not need those soft laws?
Well, I think they play a very important role, because the how should I say, gathering from, in particular, the International Bar Association arbitration people, calling upon in the committees that do this on civil law lawyers, common law lawyers, people from different parts of the world, and coming up with their basically rules on presenting evidence in international arbitrations, on conflicts and so forth. They already represent a kind of a coming together of international arbitration experts from around the world as to what they can agree on commonly. And so they are, on the presentation of evidence, for example, they are commonly included in ICC terms of reference, or in terms of appointment, or procedural orders number 1, as guidelines. They're rarely accepted as fixed, but guidelines is enough, and people follow them. I think those are very, very good developments. And I do. There have been so many cases in which the tribunal consists of a mixture of civil law lawyers and common law lawyers, that after some time of experience together, they begin to appreciate other systems. I know Karl-Heinz Bergstiegel from Germany, who was president of the Iran United States Claims Tribunal, and a terrific one, and someone with whom I've sat in a number of cases since then, has often expressed his having come to an appreciation of the Anglo-Saxon system of cross-examination of witnesses. Now, I know there are still some civil law trained lawyers who basically don't want to hear testimony from anybody who knows what happened. They just figure you can't rely on someone who is an officer, director, or employee of a party, and they look at the documents. I think that's largely been watered down. But I remember asking.
Right.
It's anyway. I think it comes more and more there's more and more of a convergence with the exposure of everybody to the other systems.
Okay. Let me switch gears now to I would say the hot topic of this year, 2020, which is COVID. Well, the famous scientist, biologist, and botanic Englishman Charles Darwin used to say that the only unchangeable thing in life are the changes. So we are living what we call the new normal. And this new normal goes also to arbitration hearings. I would like to know a little bit of your insight, your inputs regarding arbitration hearings, and if you think those virtual or remote hearings are going to be here for unforeseeable future, regardless the arrival of a vaccine? Do you think that, and also, if I may, just to cover all this COVID topic, do you think that always a virtual hearing is now necessary, or is there any way that despite of COVID, an in-person or somehow hybrid hearing is necessary?
Well, under present circumstances, I have not had a hybrid hearing, although in one case, a party very much insisted upon it, but was overruled by the tribunal. That will probably be used against the tribunal if that party loses and seeks further relief. But there have been very few cases of which I'm aware in which there has been incredible insistence on an in-person or even a hybrid hearing. And I have heard of in-person hearings that have taken place. Well, great for them. I'm not willing to risk. I'm not willing to risk traveling across the Atlantic or the Pacific at this particular point. And I think a lot of I've been involved with different systems, different operators of the system. They've all worked quite well, and I think the conditions that are imposed are quite sure to keep everything nice and clean, as it were. Now, as for the future, assuming we don't have to worry about COVID-19 anymore, whenever that happens, which I think is a ways off, there will be, I think that the savings that may be seen in relatively small cases, and particularly which are strictly commercial cases between two private parties. Well, I mean, let's save that money. Let's not travel. Let's not do this and that, and we'll do it that way. But I think in the bigger cases, and the what I would describe as more political cases where governments are involved in one form or another, or what I always refer to as bet the farm cases, everybody's going to want to get together. Considering what the overall costs of engaging in the arbitration are on both sides, the expenses involved are be fairly minor, and of course the arbitrators whose expenses are paid would certainly be happy to the extent they can, to revert the old way where they can all have many times they've sat together before and they all know each other. But our community is not geographic, it's worldwide, so we don't get together that often. I'm sure we'd be glad to have dinner together. Now, that's not a consideration. That would just be a side benefit. So you will have some that will continue to be virtual, and number of others that will not be at all.
Interesting. Okay. You are an arbitration giant. So if I'm not wrong, you are not a mediation practitioners or a mediator, but due to coronavirus scenario, do you see a rise in the use of mediation as a method of solving conflict in the international arena?
I don't know that I can say that the coronavirus would promote that. I think it's the coronavirus affects that the same way it does arbitration. I do believe, however, since I've had occasion to study it and speak about it, the Singapore Convention mediation, I think, is a tremendous step forward, because it will give international disputes where the people wish to mediate the advantage that if they meet the conditions of it, it can be enforced, just similarly to the enforcement of arbitral awards under the New York Convention. And there are large parts of the world that appreciate mediation more than they do arbitration.
Yeah. And the Singapore Convention, by the way, is already it's coming to force.
Yes.
So let's hope that those mediation agreements and mediation settlements can be enforced as the arbitral awards are enforced under the New York Convention. And talk about New York Convention. There are some discussions regarding the possibility or the idea of amending the New York Convention. Let's forget for the moment all the difficulties in the international public scenario of getting all these countries to agree. But in terms of substantively speaking, would you like New York Convention to be amended? And if so, why? If not, why?
Right. I'm not really an expert on the New York Convention. I say spend all my time creating or being involved in awards which somebody else then tries to get enforced. All I'll say about revising the New York Convention is going back to the premise that you stated. It's an old saying: "Be careful what you wish for. Don't open anything so well established to 100 and more countries to tinker with. You won't like the result."
Right. Okay. I know that unfortunately our time is about to end, but I have a final question for you, and this is a crystal ball question. Well, let's assume that we are in 2030, 2040, 2050. Any crystal ball as to how international arbitration will look like by then?
Yeah, well, if you tell me what the world will look like, then maybe I'd be able to give a prediction. But it depends upon so many things: political, economic, and cultural. I certainly hope expect it will survive. I think it's in a period of potential transition, not only because improvements are constantly made in it, but also just what will happen with the European Union idea on this will have an influence. Maybe other things will have an influence. So I'm not I don't think I'm reluctant to make 30-year projections of what will happen anywhere.
Okay. Are you a optimistic person as to the future of the world?
Oh, well, one has to be optimistic. It's our duty. If you're not optimistic, it's just like if you're not an internationalist in this business, you must be in the wrong place. So we have to be optimistic.
Perfect. Judge Brouwer, thank you so much for your interview, your time. It's been fascinating. It's been very rewarding to exchange these thoughts with you. With that said, I'm going to ask João Moreira to step in and to conclude our program today. Thank you very much.
I thank you very much for the opportunity.
Thank you, Mauricio. Thank you, Judge Brouwer. Well, My name is João Moreira, and I'm one of the organizers of the 5th Oxford Arbitration Day. I'm sure everyone like me enjoyed the fantastic speakers we had today. I'm here to tell you that unfortunately the 5th Oxford Arbitration Day has come to an end, but I would like to take this opportunity to, in the name of the Oxford International Arbitration Society, thank again our sponsors, CAMCCBC, Gomm International, the GST, Moraes Leitão, Talio Checker, Meyer Brown, Aprigliano Advogados, Baraldi Mariani Advogados, Cascioni Advogados, Lobo de Riso, Luca Advogados, Marchini Botelho Caselta Advogados, Rodrigo Mendes Advogados, and also thank our institutional supporters, SBAR, o Comitê Espanhol de Arbitragem, e TDM OGMID. Finally, I would like to express my sincere thanks to Lauro and Fernando from Canal Arbitragem for their magnificent handling of all the technical issues related to this conference. They were they were an integral part of the success of this event. I also have to give thanks to my co-organizers, to Anna, Andrea, and Felipe. It's been a pleasure, as in all other years, to work with you in organizing this event. And I'm very happy to see that all the hard work has paid off. As you might be aware, this event partners up with Educa Foundation, and the funds that we raise from sponsorships will provide for a needs-based scholarship for a future master student. I'm very happy to inform everyone that we have yet again this year achieved our fundraising goal. With this great news, I will conclude the event by thank you everyone that has attended today and by inviting you to join us in next year's event that hopefully will take place in Oxford, and we can all meet there and have hopefully a great time. I wish everyone a great weekend, and thank you for having joined us.
Thank you.